Okay, I think that's all running fine now, and we can get started. Okay, so thank you so much for being here. It's always nice to be doing these sessions on a Wednesday morning with you, and I do miss them when we're not able to do them. So some of you will have been before to these sessions on a Wednesday. I recognize some of the names, and for some of you, this might be the first session you're doing with me on my regular weekly talks that I do all around divorce. If it's your first time, just so that you know what happens, I talk for about 20 to 30 minutes on whatever subject I'm covering. And I'll tell you a little bit about how I work, and then I will answer your questions. So if you have any questions coming up for you, do put them in the chat box. You can send them to me privately if you don't want to share publicly. So feel free to put them in the chat box privately, and I will answer those for you. It's an opportunity for you to get some help with whatever questions are coming up for you. The session is normally about 45 minutes, although it can go slightly over depending on the topic. So that's how the session runs. Feel free to engage with me in the chat box. Again, privately is absolutely fine. Feel free to put things down publicly if anything's coming up for you. But what I do ask to begin with is if you could let me know where you are up to in the divorce process. Is it something you're thinking about? Is it something that you've decided on? Or have you already begun? And if you have begun, where are you up to? So I would love it if you could put that in the chat box privately or publicly, that's fine. I won't say your name if it is private, so don't worry about that. It just lets me know who you are, where you're up to, and that way I can make sure what I'm talking about is tailored to you. So today's talk, while you are letting me know where you're up to in this process, today's talk is all about fair settlement. So many people talk about their financial settlement, and they believe that it is 50-50, that they have to share things. But actually, it's not necessarily 50-50. What we are looking to achieve is a fair settlement. And I'll take you a little bit through what that means and how you can decide what a fair settlement is for you. So I'll let me just share screens. Let me know if you can see that okay. Actually, that isn't coming up great for me, so let me try that again. Doesn't seem to want to share. Strange. Okay. I think that is working fine. So what is a fair settlement? And that's what I'm talking about today. And a little bit about me before I start. My name is Bhavna Radia. You may have come across me previously. You may have found me through social media or recommendation. My background is as a family lawyer, and in 2011, I went through my own divorce. And at this point, my 3 children were very young, and I realized how devastating this process is for my clients. And during that time, when I went through it myself, I realized just quite what you are going through. And I think that really made me want to work differently with my clients. And so I started on this journey of trying to find something really different to help people through divorce, because I now understood that divorce is not just about legal advice. Yes, that's really important to get the right advice. But actually, getting just somebody telling you what the legal process is not sufficient. You need a more holistic approach where somebody is able to guide you in keeping your costs down, making this process as amicable or less hostile as possible, without having to go to court if you can help it. And of course, for some of you, court proceedings may be the only option, but it's not where we should start, and we shouldn't rush to that point. My children are much older now. I've been a single mum for 13 years. They're 23, 20, and 15, so much older, and all doing well. And I remember I was so scared of the finances because I'd taken a career break for a short time just so that I could bring up the children. And financially, I was really worried about how I'd make ends meet. And that often comes up for people when they're going through a divorce. They're really worried about the finances. And you'll hear lots of talk about this thing called a fair settlement. And I remember thinking, that's what I want. I want a fair settlement. I was able to help myself because I have legal knowledge. And through these sessions, I look to offer information and knowledge to you as well, so that you are able to manage as much as you can of your divorce yourself, or at least have a really good understanding of how things work. So that's a little bit about me, just in case it is your first session. So what is a fair settlement? That's the question. What does that mean? It's a financial agreement which is fair and reasonable, taking into account your whole situation, the needs of your children firstly and as a priority, and then the needs of the two of you as well. And the law tells us different factors that we need to take into account so that your agreement is fair and reasonable. And these are at Section 25 of the Matrimonial Causes Act. And how these factors are applied will depend on your individual circumstances. So they help you reach a fair outcome. And I'll go through them for you so that you understand what kind of things you need to take into account when you're looking at your own financial settlement. As I said before, most people think that the court will be looking at a 50-50 split. That is not necessarily a fair outcome. It might be the starting point that you look at. So a court will think, is 50-50 fair? And it may be that it isn't fair in your circumstances, especially where one person possibly has a lower earning capacity, even where maybe there is not much equity in a property or limited savings, pensions, for example. So if the marital pot is not very big, then a 50-50 split can lead to injustice, really. So just bear that in mind, that 50-50 is not necessarily fair and reasonable. And the other thing to bear in mind is that it doesn't necessarily matter who has what in their name. It doesn't prevent it being included in the list of assets. So for example, if the family home is in one person's name, it doesn't mean that that person owns it only. They may have it legally in their name, but both husband and wife will have a beneficial interest in that property. So don't think that just because something isn't in your name, that it shouldn't be included in the marital pot. It should be included and possibly shared as well. And ideally, what the court is looking for is for you to be financially independent of each other. And this is called a clean break. The court doesn't really want you to have continuing financial links. So, for example, keeping a house in joint names. The court prefers that you move away from this financial link because it can cause arguments, that there can be a whole load of issues that come from keeping assets, liabilities in joint names. So what they prefer is for assets to be transferred into one person's name or the other, or sold. rather than keeping things in joint names. But sometimes there is no choice, and you do have to keep, say, for example, property in joint names. And in certain circumstances, that is fine. And as I said, for some people, a clean break is not possible. And so the court would be accepting in that situation if you couldn't have a clean break. So let's move on. What are the factors that need to be taken into account? So when we start looking at your settlement and your situation on a sort of short, medium, and longer term, the court tells us what we need to take into account. And regardless of whether you reach an agreement yourself, you have friends or family helping you, you do it through out-of-court dispute resolution, or if you do it through court, it doesn't matter how you get to that end result. These factors are taken into account regardless. So I'll go through them briefly, just so that you have an idea of what they are. And as I said before, the welfare of the child or any children of the family is priority. So if you have children that are under 18, their needs have to come first. They have to be priority in whatever you are doing, whether it is around the finances or even if you are coming up with a plan for children. So when you're looking at what is fair and reasonable, you have to take the needs of the child into account first. And that might mean sometimes that the main carer of the child, whoever will be doing most of the caring, may need to live in the family home. So, for example, their schools might be nearby, their children's friends are nearby, the support network they have is nearby, their extracurricular clubs. So it might be best for them to remain in the house with the person that will be doing most of the care. So in that way, we're taking their needs into account, and that would make it a fair agreement. The next element there is income, earning capacity, property, and other financial resources. So when we look at income and earning capacity, this is important. If there is a big difference in earnings, it may be that one person doesn't have much mortgage capacity. It may be that they are not able to afford their expenses. And so we need to take that into account, because the settlement needs to be not only fair so that both of you have housing and your children have housing, but also that you can meet your monthly expenditure. So that needs to be looked at. But also the person with the lower income, we need to consider whether they could increase their income in some way. Could they take on more hours? Are they doing a job that potentially was school time, but they don't need to do that anymore? And so is there a possibility of getting another job that could increase their income? And it isn't just income now, it could be income in the future that we're looking at. For example, one of you may have that the capacity to earn really well in a couple of years' time, because that's where your job is going, that's where your career is going. So that should be taken into account as well. Also taken into account is property that may have been purchased prior to marriage. So that usually is left out of the marital pot because it was purchased prior to the marriage, and this is only in some circumstances. It may need to come back into your calculations if there isn't sufficient there for both of you to be housed and your children to be housed. So any property that you might have that you think needs to be left out may need to be brought back in if there's not sufficient assets. So that's what the court means by financial resources and property. Financial need, obligations, and responsibilities. This is the needs that you have, and it's a big part of how we work this out. So you will need somewhere to live, both of you. You will need enough income to live on, and you need to consider what will happen to you on retirement, so your pension needs as well. So we need to consider that first. Where do you need to live? How much money do you need to be able to purchase a property that fits your needs? And how much does the other person need to purchase a property that fits their needs as well? So from that point of view, we have to look at all of these needs that you may have. Obligations are debts that you may have, liabilities that you may have that you have to pay, for example. It may be something like private school fees that you're having to pay as well. And then we come to standard of living. A standard of living, it would be ideal if we could keep you in the same standard of living that you have enjoyed during the marriage, but that isn't always possible. So what we try and do is have a similar standard of living between the two of you, so that at least one person is not disadvantaged. And that, we have to it depends on the circumstances as to how we can meet your standard of living as well. Next one is age. Age is important because if there is an age gap or one person is older than the other, that can have an effect on mortgage capacity. It can have an effect on how long you could continue working, how much you could pay into your pensions, for example. And then length of marriage. This is again something we take into account when we're looking at how you share your assets. If you've had a short marriage, for example, if your marriage has been a year, what might happen is that you keep whatever you came into the marriage with and you split whatever you obtained during the marriage. So if you had a property before you got married and savings and a pension, you could leave with that. And if you bought a property in joint names together with the other person, it may be that that property is sold and the proceeds split. So if you've got a short marriage, generally that's how we look at it. For longer marriages, we are looking at more likely for assets to be divided equally or shared. So if you've had a 30-year marriage, then we generally are looking at equal division of the assets. And then we come to physical or mental disability. If you or your child has a physical or mental disability or illness, this needs to be taken into account as well when we're thinking about how you share your assets. Because with a physical disability, it might be that you have to remain in a family home that's been adapted for you. It might be that the disability or illness makes it difficult for you to work, which then also needs to be considered as well. So for all of you, if there is a physical or mental disability, we have to look at what this means and the best way of meeting that need. Then we come to contributions, and now this is a really interesting one. I do hear lots of people saying, well, I've been the higher earner, so I've paid more towards the mortgage, therefore I should get more. And the courts they don't look at it that way. If one person has been earning more, potentially the other person might be working part-time because they're bringing up the children or taking on more of a role at home, then this contribution of doing more at home, bringing up the children, taking the stress of the main breadwinner is also considered equal to any financial contribution. The court sees you as a partnership, and so the court would not look at who paid more. Who paid more bills, who paid the deposit. This isn't generally taken into account. They look at your contributions to the family as equal. Then we come to behavior. Now, lots of people talk about behavior. They might say things like, well, the other person committed adultery, so I should get more. The other person, their behavior was unreasonable, so therefore I should be getting a greater share of the assets. And usually behavior is not taken into account unless it's something that's very extreme. So, for example, where one person is gambling very heavily, and this has meant that they have built up debts, and they have gambled away savings, investments. Potentially the family home has been remortgaged a couple of times to pay off their debts, and they still get into debt. It might be that if they've lost 300, 400,000 in their gambling behavior, that this is taken into account, for example. So that's just one example of behavior that's taken into account. It's usually financial behavior. If one person has committed adultery, that's not normally taken into account when we're looking at finances. If one person has made the decision to divorce and the other person doesn't want to, again, that isn't taken into account. We're looking at extreme behavior, really. I just wanted to talk a little bit about needs because this is quite an important area. In most cases, there isn't enough money in the pot for both of you to get what you want. So you may have always lived in a 5-bedroom detached property in quite a nice area, and it might be that it's not possible for both of you to have a house like that because there isn't enough in the pot. So then we first have to look at what you need. Once we have met everybody's needs, if there is anything left in the pot after meeting everyone's needs, then that can be shared. So when we talk about needs, as I mentioned before, housing needs, that's the first consideration. Where is everyone going to live? What are their needs? Do they need a swimming pool or is that a want? If you've got children, do they need a bedroom each? Do they need a property that is close to their schools in the area so that they can travel to school? You can drop them, they could walk. If you've got children with disabilities, then their needs for housing will be different. If you've got disabilities, then your needs will be different. Once we've worked out what your needs are, we need to think about how we meet them. And this is for both, not just you, it's for the other person as well. We have to look at needs for everybody. When we talk about capital needs, this is what you need in savings to cover other extra things. So, for example, if in the family you have one car, and when you separate, one person will be taking that car, and you may need your own car. So we have to leave an allowance there, a capital sum for you to be able to buy a car if it is possible. It may be that it isn't possible for you to buy outright, but where it is possible, we might need to make sure that you've got funds to meet that need. It may be that we need to put funds aside to pay off liabilities or any debts that there are, for example. Income need is everything you need to manage your monthly outgoings. So if your income, once we look at this, if your income doesn't cover your expenses, what can be done? It might be possible to increase what you've got coming in. It might be that you'll get child maintenance or spousal maintenance from the other person, and that could increase your income. It might be benefits. You might take on more hours at work, for example. Then we have to look at your expenditure as well. And so you look at how much you're spending, how much you've got coming in, and how you can make sure you don't go into debt every month. And this income needs can form part of your settlement. So maintenance could be part of your settlement. So you know that financially you'll be able to meet your monthly expenses. And then the final consideration here is pension needs. Generally, we have to look at what is going to happen to you on retirement. So how will you meet your expenses during that time? Sometimes you might have a pension, the other person may have a pension, and you can meet your pension needs through the pension you have yourself. If you don't have a very big pension yourself, but the other person does, because maybe you've been working part-time and not putting money into your pension, and the other person has been, what can we do? It might be that in your settlement, you need to look at a pension share order, because that way you get some pension as well, and we know that you will be fine financially in the future. So we do need to consider that. It may be that you decide that you want the family home, the other person can keep their pension, and on retirement you'll downsize and you'll have a lump sum potentially to put towards your expenditure every month. So this is all about needs. And what else do we need to consider? So I've told you the Section 25 factors that we take into account. I've told you all about needs and how we have to look at meeting your needs depending on your circumstances. The next element is that some assets will not be matrimonial assets. They will not come into the marital pot to be shared. So what assets could be non-marital and what is marital? So money and property that is non-marital would be left out of the pot. And this can be, say, for example, property that you purchased before you got married, a pension that you had paid into before marriage, for example, that may not be shared. Also, inheritance potentially could be something that isn't shared if you haven't mixed it with family funds. So there is always a question mark around these things. So we would need to look at your circumstances to work out whether property that you purchased before marriage is marital or non-marital. If you've got money in an account that was your inheritance, is that marital or non-marital? Anything that we have decided should be part of your marital pot is there to be shared. It may not be equal shares, it may be slightly different, but it is there as part of your financial settlement. It has to be included in your agreement. Non-marital assets could be left out. So that's another step that we need to look at. So I've given you lots of information. How do we put this together in a step-by-step process? So the first step is, what are your total assets? That's the first thing we need to look at. What do you have? What are the valuations? What is in your name, the other person's name, joint names? What assets do you have an interest in that you don't even have your name on? And this is assets that are in this country and abroad. So we need to first work out what your total assets are. And this is actually called a process called financial disclosure, which you may have heard of previously. And financial disclosure is both of you being transparent and honest about what assets you've got. Once we have got that total asset, we look at what is in the matrimonial pot to be shared and what can be left out. So then we've got slightly different total assets, possibly, that is there to be shared. Then we look at your needs. What are your reasonable needs? And once we know what your needs are, do we have sufficient here in the pot to cover your needs? If we do, great. Then we look at how best to share everything to meet your housing need, your income need, your capital need, and your pension needs. And we devise a settlement that meets all of those needs. If there isn't sufficient, so we know what both of you need from a housing point of view, if there isn't enough there to meet your needs, then it might be that anything we left out as non-matrimonial will have to be used to meet needs. For example, if your total marital pot is 500,000, but one person has a property that they purchased prior to marriage that they get rental income on, and that's worth 300,000, but it's left out of the pot. When we look at the 500,000, it may be that there isn't sufficient there even to buy two properties. And it might be that the court will say that actually that non-marital asset needs to be brought back in. Maybe one person who owns that one could move in there, and the other person could sell the family home and use some of the proceeds to buy their own place. And it might be the remainder of the proceeds goes to the other person. So it can be a little bit complicated, but this is how we work out a financial settlement that is fair and reasonable in the circumstances. So I hope that that's made sense, and actually bringing it together in a step-by-step format so you could see how it could work. Okay, so that's what I wanted to share about fair financial settlements, and I hope that's been useful and given you something to think about. Feel free to drop me some questions. I can see that there are some there around financial settlements or anything else really. And as I said, you can put them in the chat box privately as well. I'll tell you a little bit about how to work with me quickly before I come to the questions as well. So there are various ways to work with me. You can work with me on an ad hoc basis, one-to-one. So as and when you need it. I have a fixed fee support program, which is 6 months of my support and guidance throughout your divorce process, decisions you need to make, finances, children, anything that is coming up for you, wills. There's so many things to consider around this time. We talk about everything and I guide you on everything. It's a fixed fee because actually when I was going through my divorce, I felt so grateful that I didn't have to instruct lawyers and worry about the spiraling legal fees going up and not knowing where that could end. So I decided to offer a fixed fee so you are not worried about your costs going up. I help you with everything. So correspondence, letters coming in, documents you need to prepare, a divorce application. We are looking at financial disclosure, what there is in the pot, what needs to be shared, what proposals we can put together to come up with something that meets your needs, meets the other person's needs as well, and then negotiate to get you to an agreement. So we also cover children and arrangements for children, court proceedings if unfortunately you do end up there. And there are other experts that come in to talk to you as well. So that is my fixed fee work. I do work with you ad hoc, and I do have some new services coming out that will be really super useful for you as well. So just a little bit about how we work through somebody, one of my clients. Now, Pam has two children aged 17 and 15. She's worked part-time for many years while the children were growing up. And due to circumstances, the main asset was the family home. What they'd done was used up savings to renovate the family home because it really needed a major refurb. And as the children were growing up, they needed their own bedroom. So they used up their savings for this renovation. Then this situation arose where they were going through their divorce, and she made the decision that the marriage was over. And she was really scared. She was really emotional, really just didn't know what to do. And when she came to me, she was crying quite a bit, very emotional. During the marriage, her husband was an alcoholic, and their children and her had been dealing with the fallout from this addiction that he was suffering from. And so as much as it wasn't her wish to get divorced, she knew that there wasn't really a choice. And she needed to try and save the family home for her children and also for their mental health as well. So when we worked together, we came up with a plan, which is really important to decide how to move forward and the best way of getting things done. We did her divorce application first and then started getting her prepared around the finances. So understanding her finances, knowing what the numbers were, understanding her income and expenditure, and really coming up with proposals that would meet everybody's needs. So I created 3 proposals for her that were possible. And then we went through each proposal and made sure that it was viable, that we could make it happen, because there is no point having a proposal, a financial settlement that you actually can't follow through with, which I see people do quite a bit. So I sense check each proposal and I help during the negotiation as well. They did get to an agreement, luckily. The consent order was drafted and sent to court. The problem they had was the financial settlement was more in favor of her and not her ex-husband. And there was a reason for this. So the consent order was actually returned by the court, and we knew that it would be. It was returned by the court, and the judge asked them to come in for a 5-minute hearing. Both of them went. They explained to the judge their reasoning, and the judge stamped it, and they managed to get things resolved. And she's much stronger. She feels that she could deal with any challenge now after having been through a divorce, but she managed the process herself alongside my guidance as well. So that's how the program works. And we went through the whole process with her in 7 months. So we were very lucky to get everything done in that time. I get lots of testimonials, reviews, and this was actually from her saying the stress is over. It was a bit emotional. She came on the call to share what happened with her divorce, and she hopes to inspire them as well. And she let me know that she was grateful that she found me and that I was guiding her through this time. If you want to know if any of my services would be a right fit for you, then feel free to reach out. We can have a quick chat. We can see how you need things to be, and we tailor what you need. So we have to find the best fit for you with whatever we decide to go forward with. So book in a call if you would like to know more, and I'm quite happy to take you through that. Nelma will just pop the link in the chat box for you. I also have a book, The Divorce Planner, which is on Amazon, so you can purchase from there. It helps you take action and gives you worksheets to fill in to help you move things forward. So feel free to look at that as well. And there's lots of different ways that you can connect with me. I share quite a bit on different platforms. You can reach out via my website or email address. You'll see lots and lots of resources and videos on YouTube, which is the one at the bottom. If you could subscribe, that would be great, and you'll see everything new that's coming out. I've got quite a few new things coming out on YouTube, and that's where I'll be sharing them. So if you subscribe, at least you'll be able to get that information as well. So that's everything I wanted to share. Let me have a quick look at your questions as well. So let me stop sharing and answer those. I hope you found that useful. Was there something there that you could take away? Do let me know. Okay, I'm currently going through a divorce after being in an abusive marriage, and it's been really tough. One of the biggest challenges I'm facing is trying to negotiate with someone who's very difficult and controlling. It feels like no matter what I do, it turns into a power struggle, and getting to fair settlement seems impossible. On top of that, I'm struggling emotionally, trying to cope with the stress of it all, also, while dealing with the trauma from the relationship. I'm not even sure what fair settlement looks like in this situation. How do you negotiate with someone like this to reach a fair settlement quickly? Really good question, and something I get asked all the time. And it is really difficult when you know the other person is controlling. They know exactly what they want. They also know that if they make this hard for you, you are likely to get tired. You are likely not to be able to cope, and you will then agree to their demands. And we see this all the time. And it's really hard to stay strong in the face of all of this that is happening. So I completely understand what you are going through. When you are negotiating with somebody like this, sometimes it can be so difficult. And it sounds like you're negotiating directly with that person, which I get. It's so hard to get a straight answer. They're always hiding something. They will not see sense. And sometimes when you're arguing, they are able to change things around, and it makes you doubt yourself. And these are and they won't hear you out. So your voice is not heard in all of this. So I completely understand what you are saying. The first step, which you've tried, which is to negotiate yourself, I would always, for somebody like this, have deadlines and a plan in place, because you may try something and you may wait 6 months, you may wait a year for them to agree with you, and you might find that they're never going to agree with what you're saying. Mediation could be the next step, but again, they may still control the narrative through mediation. They may cause delay through negotiation in mediation, and they may not be honest about disclosure, financial disclosure. And so that's a difficulty with mediation. If you use mediation as an option to find out as much as you can about what that person is saying, what that person's view is, how they are going to manage this process, and maybe use it as a way of getting financial disclosure, if you haven't already, then it can be useful for those things. Often someone who's controlling won't listen to the mediator who says, we need to see 12 months bank statements for this account, you've not provided them, for example. And they just won't want the narrative to be controlled by a mediator either. So they just won't provide it. And at that point, they'll leave mediation potentially. You should again have deadlines for how long you will try mediation. If it doesn't work, really the only step that can be open to you, if you have tried everything to get to settlement and it's not possible, the only next step is through court proceedings. And someone like this will control the court proceedings as well. And you do hope that at some point the court will see through what they are doing and give them consequences of their action. So it may be a penal notice where they get arrested if they don't do something. It might be them having to pay your costs for hearings as a punishment because they're not doing something or that they're refusing to comply with court orders. So these sort of things can help through court proceedings. Even court proceedings are not easy with someone who's controlling, but slowly, step by step, you could maybe get disclosure and be in a position to either negotiate through court proceedings or be in a situation where the judge makes a decision for you. It's definitely not easy dealing with somebody like this. And sometimes when we look at it, it is best sometimes to look at a settlement that just gets you out. I hear lots of people saying, I just want to get out of the situation and I'm willing to accept less to do that. And obviously that's a personal choice. I hope that answers. It is a very difficult situation you're in. I've got a direct message. Thank you for the talk. I inherited the property from my dad. I've been living in the property for 7 months with 3 kids, 10, 12, and 15, and the other 2 kids. With the kids, she is staying with her parents, aged 8 and 17. She sends a letter of demand asking 60% of the property. So I'm a bit confused actually what your question is. She sends letter of demand asking 60% of the property and 5 custody of the children and wants to move into the house. I need to vacate the property. And she said I could keep my pensions. Is this reasonable? Okay, let me just look over the question again. So it's a property that you inherited that you're living in. She's asking for 60% of this property that you inherited, and she wants custody of the children and wants to move into the house, and I need to vacate the property. And she said I could keep my pensions. Is this reasonable? It's never possible to answer a question like that. I mean, I don't have enough information. I don't know what the property is worth. I don't know if there's any lending on the property. I couldn't tell you if it's definitely out of the pot without having a proper conversation and advising you. I don't know what your pensions are worth. It's difficult to know exactly if it's reasonable. You need to do a full process of disclosure and then look at whether that's reasonable. I've already invested 100K into the property. I've paid the mortgage. I want to get back together. She doesn't want to. That bit isn't relevant. Whether you want to get back together and she doesn't want to, that won't make a difference with the finances. If you've invested 100K renovation out of your pocket into the inheritance that you've had, that 100K may be marital assets. And so therefore, if you've mixed marital assets into the property, it may be that that property is now part of your financial settlement, but I couldn't tell you if it was reasonable. I was married for 20 years, had 3 children with my ex, and we split up about 1.5 years ago. We sold the family home, went 50-50 on the equity. Since then, we've been living separate lives, but we're technically married. Now I'm thinking of getting a divorce to sort everything out once and for all. My question is, how do I make sure the divorce is fair financially for both of us, considering we've split the house money and we need to think about what's best for the children? Well, firstly, we need to look at what assets you have. So although you split the house, you What happened around your pensions, savings? Did you both just keep the savings you had and the pensions that you had? Is that what you're hoping to continue with? That you keep your pensions and the other person keep theirs and their savings? So it's difficult to know if what you agreed when you separated was a fair agreement. It may have been fair, and then all you need to do is get divorced and get a consent order that makes that agreement on separation legally binding. But it depends on whether it was fair at the time, and it depends on what you're trying to negotiate now. Okay, got another question, direct message. I earn 60K, but in debt, plan for 100K, and she earns around less, 10 or 15K. She lives with her parents and she has her name on the will. Again, the name on the will is not relevant because it's not inheritance she's got. And even if she had the inheritance, it may be possible to leave it out. Although she lives with her parents, she does have a right to live in her own home as well, not just live with her parents. With her sister, afterlife interests of her parents. Not sure what you mean by that. She claims child benefit for all 5 children. If they don't live with her, then maybe that needs to change. And also, she claims other benefits. Because she's on low income, she probably has an entitlement to benefits. But you need to do financial disclosure and work out what would be fair in the circumstances. Okay. Topic next week, negotiating your way to a better divorce. So we're actually talking about negotiation next week, which is a really good topic because it's not something lawyers talk about very much. It's not something you hear about a lot, but actually, if you negotiate well, you can settle matters yourself. Although for some people it is very difficult. Thankful for these sessions, extremely useful advice. Thank you. I need to leave. Okay, so I'm glad that was useful. Thank you so much for being here, and do reach out if you need any help, you want to find out what service would work for you. And I will definitely see you next week on Wednesday. Next week's session is moving to 12 o'clock, I believe. So just so you're aware that if you're joining next week, it will be at midday, just to make it easier for people to join. And there should be a replay coming out to you as well. So do look out for that. Lovely to see you all, and take care. Bye-bye.